This will drive some people absolutely crazy because after Elon Musk funded Tommy Robinson's legal fees, he's now been found not guilty of the terrorism offence of refusing to provide his PIN code to his mobile phone in July last year. But the full reasons as to why he was found not guilty, I suggest are possibly not going to be fully explained to you by the mainstream media. So if you would like an alternative voice to the mainstream and all of the details and what really matters because you deserve to hear it, do subscribe to the channel and I'll be very grateful. So let's get into this, shall we? So the brief details, if you were not familiar, are these. He was charged that on the 28th of July last year at the Channel Tunnel in Kent that he willfully failed to comply with the duty imposed under Schedule 7 of the Terrorism Act, in that he failed to provide his PIN code to the police to his mobile phone, contrary to paragraphs 18(1)(a) and 2 of Schedule 7 to the Terrorism Act. Now, there's an important bit of law here, which the judge did pick up on, which I've talked about in previous videos, which could make it very difficult for anybody to get away with, and I'm not encouraging anybody to get away with anything, but to get away with not giving the police, when so questioned under the Terrorism Act, to your mobile phone. Now, let's look at what the judge said here. At paragraph 11 we're looking at. We'll come back to paragraph 7 in a second, but the judge said, of particular note, an examining officer may exercise the powers under Schedule 7 whether or not he has reasonable grounds for suspecting whether a person falls within Section 41B, which is someone who may or may be likely to be a terrorist. Now, that's really important because much of the law turns on whether an officer has reasonable grounds for suspecting this, that, or the other. Now, this does not apply to Schedule 7, so it doesn't matter whether there's reasonable grounds or not. Now, that doesn't necessarily mean that a stop and questioning can't be unlawful, as you'll find out in a minute, but let's go back to the law first of all, and then I'll explore what really happened, which is quite staggering, to be perfectly honest. So let's look at paragraph 7. Paragraph 2(1) of Schedule 7 of the Terrorism Act gives the power to an examining officer to question a person at the border for the purposes of determining whether he appears to be a person falling within Section 41B. And just to be clear, 41B is that in this part, a terrorist is a person who is or has been concerned in the commission, preparation, or instigation of acts of terrorism. So they have the power to question anybody to determine whether they may or may have anything to do with terrorism. They don't need, as paragraph 11 says, this is really important, they do not need reasonable grounds for suspecting whether they might be under that section. They can just question you for it. But that's not the end of the matter. So back to some of the details, which will be relevant in this case. When he was stopped, he was escorted to an interview room, served with a notice of detention, read out to him in verbatim. He signed the notice, legal rights explained, and so on. And he was told that he was required to provide the PIN code to any electronic devices. He was provided with information leaflets. He and his luggage was searched. They took off him £13,000 odd. And then his iPhone was seized, and he stated to officers that he had journalistic information on the phone and therefore would not provide the PIN. He asked for legal advice. No further questions were put to him at that stage. Now, P.S. Farmer, as the reviewing officer, then explained to him his role and obligations under the legislation, and he confirmed that he'd not be providing the PIN because it contained journalistic material. Now, this is what you will see the vast majority of the news outlets saying to you that was the defence, which is not entirely accurate. Whilst this is what was said at the time, and it was one of the arguments, that's not the fundamental reason the court found him not guilty of this offence, which you'll find out in just a minute. Now, just before we move on to the law and a full explanation as to why he was found not guilty, this is really important to you because the principal reason it will turn out that the police had stopped Tommy Robinson in the first place was because he had a public profile, people knew who he was, they knew what he stood for, and it appears that they just wanted to stop him. Full details about that in just a moment. But if there are full details about you out and about online somewhere that you, on second thought, perhaps you would not like the police to have, or your full details you would not like to be out there, I can fully recommend to you a service called Incogni, which is a service set up to remove your information from websites, from companies, from databases, to essentially erase you from the internet. Sort of your right to be forgotten. Incogni uses UK and US legislation to require that these companies remove and erase your information from their websites, helping you to disappear, because their slogan is they cannot harm you if they cannot find you. And as this Tommy Robinson case illustrates, they stopped him just because they knew who he was, and they felt like they wanted to stop him. With Incognito, you'll get access to a dashboard. You'll see all the companies that confirm that they've got and then remove your information from their servers, and you can then sleep a little bit tighter knowing that you are slowly disappearing from the internet. It is something that I recommend people do if you don't want to be known out there. And because they're partnered with my channel here, you get 60% off the annual plan using the code BlackBelt. I'll put the link in the description below. With all of this going on and the reasons I'll explain to you here, it is absolutely worth it. So grab your 60% discount. You can use multiple email addresses and you'll see the information being removed. The link's in the description below. Please do check that out. So let's take a broad look at the law first. Firstly, the judge evaluated ECHR Articles 5, 6, 8, and then later Article 10. Come back to that in a minute. Those broadly being Article 5, right to liberty and security, Article 6, right to a fair trial, 8, right to respect for privacy and family life, and of course Article 10, the right to the freedom of expression. And the judge noted that the Terrorism Act Schedule 7 did not breach ECHR Articles 5, 6, or 8, concluding that it does make some intrusion upon Article 8 rights, but it's a fair balance between the rights of individuals and the interests of the community at large. Moving to Article 10, not quite so straightforward. There was one case ruled that it was not incompatible with Article 10, but then the Court of Appeal said that the power to stop conferred under Schedule 7 is incompatible with Article 10 in relation to journalistic material, in that it was not subject to adequate safeguards against arbitrary exercise. But then, however, there were appropriate safeguards contained within the Code of Practice for examining officers and review officers under Schedule 7 of the Terrorism Act with regard to the treatment of protected material, i.e. journalists' material. But then moving to another case, things start to change a little bit. The judge referred here that the Divisional Court had made it clear that in order to convict somebody for such an offence, the court must be sure that the stop was not discriminatory. In paragraph 31, the court said the powers contained in Schedule 7 are broad and intrusive. The exercise of the power to stop and question a person does not require there to be any suspicion of an offence, which is what I talked about earlier. The power represents an interference with the individual's private life and must be exercised lawfully and proportionately. As a consequence, safeguards are necessary in order to ensure compliance with Articles 8 and 10, freedom of expression, and provide sufficient safeguards to prevent arbitrary and discriminatory use of their power. Underlying those powers is the fundamental premise that the decision to search or examine must be lawful. If the decision is not in accordance with the statutory purpose, it is not lawful. It follows that a person cannot be convicted unless the decision to search and examine is lawful. And importantly, the court then said a decision to search or examine will not be lawful if it represents unlawful discrimination contrary to the Equality Act of 2010. If there is evidence of unlawful discrimination, it's for the Crown to satisfy the court so that it is sure that no unlawful discrimination before a conviction may be imposed. Section 13 of the Equality Act provides that a person discriminates against another if, because of protected characteristics, they treat less favourably than they would treat others. And importantly here, at paragraph 19, protected characteristics include political beliefs. So putting all that into simple English for a moment, before we move on to the staggering reason as to why this fell apart against Tommy Robinson. Protected characteristics include political beliefs. So if somebody was unlawfully discriminated against, i.e. they were treated less favourably because of their political beliefs, then the stop may not be lawful. In even further simpler terms, if someone was stopped at a port, at an airport or a border, questioned under the Terrorism Act because of their political beliefs, and they were searched and examined and demanded their PIN for their phone because of their political beliefs, that may be unlawful discrimination, meaning it was unlawful, meaning they may not be guilty. But it's not even as simple as that in this case. It is that and more. Let's read on. The judge said it was identifying that there's a critical difference between legitimate political beliefs or activities and terrorism. The former is a protected characteristic and fundamentally important. Terrorism is different. It includes the use of serious violence aimed at influencing a government for a political cause. It follows that if a purpose to stop was simply to ask questions about the person's legitimate political beliefs or activities, rather than anything related to terrorism, the issue of unlawful discrimination should be at the forefront of the court's concerns. In practical terms, it may be impossible to maintain a strict line of demarcation between legitimate political beliefs and terrorism, as an obvious overlap between the matters. So yes, strong political beliefs may overlap slightly with what some people do as terrorism, but they are not necessarily the same thing. But the court acknowledged that it is difficult to distinguish between the two. Now we move on to the evidence, and this is where it gets somewhat staggering. In short, the police didn't really do a very good job of explaining themselves. Now, the judge said here that he heard from PC Thorogood. He is an accredited counterterrorism officer. He gave general evidence about how he identifies if someone should be stopped under Schedule 7, checking documents, identifying where they'll be travelling to, body behaviour, manner of travel, whether they've bought tickets in advance. He explained that on the 28th of July, he was on duty with PS Farmer, who was the supervising officer. He said that he observed a Bentley, a high-powered vehicle, unusual, with a lone driver, Tommy Robinson. He recognised the driver as Stephen Lennon. He had a belief that it was Stephen Lennon before he stopped him. He spoke to him, had concerns over his travel arrangements, travelling long distance in a vehicle not registered to him. He said his answers were vague and short and that it was a last-minute booking to Benidorm in Spain. Suspicious as to it being a long distance in a car which was not his, he pulled him over for further checks. He used his power under Schedule 7. The officer took him to an examination suite. Tommy Robinson took out his phone and then he was asked to provide the PIN, and he refused, citing journalistic material. And then the case against him starts to fall apart. Under cross-examination, the officer accepted that restraint must be exercised in using Schedule 7 powers. He accepted that the codes of practice must not be used to discriminate, and political beliefs can be a ground of discrimination. He accepted that once he starts to ask questions to decide if someone's a terrorist, that starts the Schedule 7 examination. However, in relation to Mr. Lennon, the officer could not remember when he started the examination under Schedule 7. He accepted that the selection criteria for stopping Mr. Lennon also did not appear in his first statement. He accepted that he directed him to park his car for 22 minutes behind the booth, but when asked what power he was using, the officer said he didn't know at that stage. The officer said checks needed to be made, but he could not specify what power he was using to detain him at that stage. He accepted that the powers only start when examination starts and that anyone stopped must be notified. He seemed unaware that he was left for 22 minutes. Much of what he said next he agreed was not in his initial statement. The officer then accepted that the only thing he could remember asking him was where he was going. He could not recall what other questions he asked him. When challenged about officers' concerns over his travel to Benidorm, he did not know how often he travelled to Benidorm, but then accepted that checks were made on his passage through the border, and accepted that he travels there a lot, just not through the Channel Tunnel. He said he knew that the EDL was no longer prominent. When the officer was asked what questions he asked him that were not just relating to his political views, he could not recall. He interviewed him to the best of his abilities, but accepted that before his examination, he was unaware if he'd ever been linked to terrorism. Then we move on to PC's stride, and I'll summarise the rest for you. He said he was unable to recall how long Tommy Robinson had been held in his vehicle before being moved. He stated that his memory was vague in terms of recalling why he'd been stopped, other than he bought a ticket on arrival and that it was not his vehicle. When challenged about the statement, he said, "I'm aware he moves in spheres and has links to organisations that have been labelled far-right or extreme far-right." He said he couldn't remember. He was equally vague regarding any information provided by any partner agencies during the stop. When asked about what questions were asked of Tommy Robinson about terrorist activity, he said he couldn't recall or remember. Finally, the court heard from PS Farmer. He said he advised that the reason for the stop was due to his behaviour, nervous disposition, and in a high-value vehicle. He said that he was told by PC Thorogood that he had concerns about his links to the far right. He accepted EDL disbanded in 2014, but the ideology was still present, that Tommy Robinson was driving to Benidorm and it did not add up for his profile. He said he found detention to be necessary. Other checks were conducted, but no further information was provided. In cross-examination, he accepted that he'd not recorded the selection criteria for the stop. He accepted that he did have some notes, but they've been destroyed and now only exist digitally. He was questioned about knowing about Islamophobia and the continuing ideology referred to in examination in chief. He replied that this was public knowledge. When asked that if he knew that PC Thorogood had only asked him questions for about 34 seconds, he confirmed that he didn't ascertain what he had been asked. PC Farm was also unable to give clear evidence about how long he was held at the booth before being moved, or how long the checks took. He was unaware that he'd been at the booth for 22 minutes. He said he was not part of the examination process, but undertook the reviews. He accepted that he did not seek any representations from Tommy Robinson or ask the examining officers what questions were being put to him or what topics were being explored, although he was aware that he refused to provide his PIN. When asked if he knew what questions were being asked regarding terrorism, he said he didn't know. The judge then said he's seen the summary of 4 interviews conducted under examination, and he said, as detailed above, none of the officers could specifically recall what questions were asked, over and above his political views. And so the main thrust of the defense here was not just that he was a journalist, as you probably hear from most of the mainstream, but at paragraph 36, the main thrust of the argument here was that the exercise of Schedule 7 powers to stop, detain, question, and demand the PIN were not in accordance with the statutory purpose and was therefore unlawful. No questions asked by the officers were exercised for the purposes of determining whether he appeared to be a terrorist. The reasons advanced for selection for examination do not stand up to scrutiny. Secondly, the examination and detention were exercised in respect of the protected characteristic and so unlawful. It was submitted that his political beliefs and activities had a significant influence on the decision to exercise Schedule 7 powers. In other words, it all starts to sound a little bit like he was just stopped because of his political views, because he's well known, and no real questions were asked under the law as to whether he was or had anything to do with terrorism. They just stopped him. But when asked about it, they couldn't really explain why. So accordingly, the judge said here, I find it concerning that the officers have no real recollection of questions asked of you. I found this unhelpful, and it did not assist me in being able to make any proper determination of what was in the mind of PC Thorogood at the time he made the initial decision to stop you, especially after such a short period of time, and thereafter the unexplained delays while you were stopped at the booth. His evidence does not assist me in making a finding that the true and dominant purpose was in accordance with Schedule 7. The officer also appeared confused about the powers under Schedule 7 and at what point the examination started or when he made a decision to detain you. At paragraph 39, this gave an impression of an arbitrary stop for who you are and your beliefs rather than the selection criteria. The judge said, I find that PC Thorogood had no recollection of what questions he asked of you during the examination which did not have links to your political beliefs. These observations are equally applicable to PC Stride's evidence. It does not assist me in finding evidence pointing away from the impression that this was an arbitrary stop and therefore not discriminatory. And what really sums it up for me in paragraph 41, the judge said, I cannot put out of my mind that it is actually what you stood for and your beliefs that acted as a principal reason for the stop and acted as a significant influence on PC Thorogood's thinking and decision-making. Those beliefs amounting to a protected characteristic rather than the purposes of determining whether you were a terrorist. And finally, and in conclusion, the judge said, in light of the findings, the prosecution has failed to satisfy me so that I am sure that there was no unlawful discrimination. Based on that, if the decision to stop and examine you was not in accordance with the statutory purpose, it is not lawful and I cannot convict you. Therefore, I find you not guilty. So, in short, it was unlawful discrimination because of his political beliefs, and it was an arbitrary stop because of who he was, which I believe is what he said all along, which is what a lot of people said all along. It wasn't that he was actually linked to any kind of terrorism or that he may be a terrorist himself. The judge found here that he cannot be persuaded away from the fact that this seemed like an arbitrary stop because of who he was, because of his beliefs, and was therefore discriminatory. So this is confirmation here that he was discriminated against because of his political beliefs. So this is a warning to everybody about free speech, about the exercise of your freedom of expression, your protected philosophical and political beliefs, which are protected. Now, it would seem, even under alleged offences under the Terrorism Act. So finally, a lot of people ask about questions, what you have to say to police, do you have to answer questions, and all of these kind of things. Now, there's lots of different rules about it. I won't go into them in full detail in this video. It'd be probably far too long already. But in short, there are few occasions where you have to answer the questions by police, including your name and address and so on. The big broad one is if you're out in public and you are suspected of antisocial behavior, then you do need to give your name and address. But otherwise, generally, you do not have to say anything. But you must be mindful of the question. You do not have to say anything, but it may harm your defense if you fail to mention when questioned, something that you later rely on in court. And of course, remember always that anything you do say may be given in evidence. But generally, you don't have to answer those questions. There must be a ground to search. There must be a power to search. It must be a lawful search. It must be conducted properly and fairly. It must not be discriminatory. If they come to your house, then they cannot enter unless it's for the purpose of arresting you, which I've detailed under section 17 of PACE. More detail about that in other videos I will endeavour to remember to link below. But all of these things need to be done lawfully and fairly and everything else. Now, you'll know on my channel by now that I do support the police in the job that they do, but on occasion they get it wrong. And here it would seem that it was an arbitrary stop, which was discriminatory because it was to do with his political beliefs, and it was not a lawful stop under the Terrorism Act because they didn't even ask any questions about his links to terrorism or anything else. Or if they did, they couldn't remember. And if they'd made notes about it, they no longer exist. All of which I find a bit strange because as a former voluntary police officer for about 3 years when I was very much younger, everything you do is written down. As a barrister, everything we do is written down. If you take a phone call, you make an attendance note, or you drop yourself an email, or you make some kind of note as to every conversation you've had so you can refer back to it later. Because especially as a police officer, if you do 100 road traffic stops and they all seem to be a little bit similar in the end, you can't possibly remember everything, so you write it down. But if those notes now no longer exist and they've been transferred to a digital version somewhere, the question should be asked as to where's the original, and was indeed that an accurate account of what really happened? So I hope you found that useful, the full explanation as to what really happened, not just he was frustrating terror laws and frustrating the police search, but nonetheless was found not guilty, which is what I believe some of the media is going to tell you. It's not quite that simple. It never is. So thank you for watching, especially if you made it this far, and I'll see you in the next one.